Thanks, Andrew. Good morning. My name is Kathy Chung. I'm Vice President and Senior Counsel at Merit International and a member of the Employment and Labor Committee. I will serve as the chapter host for our first program today titled Navigating the New Normal Labor and Employment Law in the Trump Administration, brought to you by ACC, NCR Region, and Gold sponsor Fisher Phillips. Please note that today's program is being recorded. All web seminar participants should have received a copy of today's slides in the reminder email. If you did not receive the email, please check your spam or junk folder. We will also place a copy of the slides in the chat box where you can download the slides directly. And if you still need a copy, feel free to email Janine Wynn. If you've dialed into today's program by telephone, please note that you will not receive CLE credit. To be in compliance with the Virginia MCLE rules, you need to be logged in with your name and company. If you have any trouble with sound, please feel free to turn on the captions for a running transcript. Look for the tool to select captions at the bottom of your screen. The first presentation will last approximately 60 minutes. You can queue up a question for us at any time during today's presentation by using the chat box at the bottom of your screen, and the panel will address your questions as time permits. However, to ensure that we have sufficient time for the CLE content, we may need to hold questions. All remarks made by today's panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoint of their company or firm or of ACC National Capital Region. And now it's my pleasure to introduce our panel for today's presentations. Robin Repass is a partner at the Fisher Phillips Washington, D.C. and Fort Lauderdale offices. Robin has more than 25 years of experience in-house and private practice advising global businesses on workplace safety, litigation, and compliance, employment law matters, and government relations related to workplace safety. She defends employers in litigation and also supports management with advice and counsel across the U.S. regarding employment law and workplace safety matters. Jennifer Jaskolka is a Chief Legal and Safety Officer at Wells. Jennifer is responsible for building out Wells' legal department and developing best-in-class safety standards. With over 26 years of experience in complex litigation, occupational safety and health, and risk management, Jennifer supports the Wells executive team in meeting its objectives and shapes a safer and more sustainable future in construction. She is committed to integrity and continuous improvement and is deeply passionate about fostering belonging, maintaining safety, and ensuring compliance with regulatory standards. So with that, let's begin the presentation.
Good morning, everyone, and thank you for joining us. I trust that everyone can see the first slide, and I just wanted to thank the ACC for inviting us to present today. And I'm also really pleased to be presenting with Jennifer Jaskolka. Jennifer and I used to practice law together a long time ago, before we both went into in-house counsel gigs, and then I eventually came back into private practice. And Jennifer is still focusing on her in-house role, and she brings a wealth of knowledge in all different types of litigation, workplace safety, and employment law topics. So thank you, Jennifer, for being here with us. And with that, I will go ahead and advance to our first slide. So here's our agenda for today. We are going to try and condense a lot into our 1 hour presentation. Because as was discussed in the opening comments, these first 100 days have been a very, very busy 100 days. So we're going to try and get through the highlights. There's a lot we will not be able to get into an in-depth discussion. And so there's a chat feature if anyone would like to engage with either of us after the presentation to learn more. Just reach out and we'd be happy to talk with you and give you anything more. Now, we're going to be talking a little bit about some of the DEI initiatives, but we won't be taking a deep dive on some of those items, such as what the OFCCP is doing, because there will be a future presenter today who's going to go into that in greater detail. So our agenda, I'm going to talk about everything going on with the DOL nominations. There are 3 that are going to begin to move fast, and that's the OSHA nominee, Dave Keeling, the Wage and Hour nominee, Andrew Rogers, and then the solicitor nominee, Jonathan Berry. Those individuals are all, they haven't been given the notice of their dates yet, but look for that to happen sometime this summer, probably within the next 30 to 45 days. And then I have another slide where I'll talk about all the other nominees and where we expect them to come in. Next, we're going to talk about regulatory shifts at the agencies from the Biden administration to the Trump administration, with some forecasts on how we believe that may shift further based on what we know about some of the nominees to these key DOL positions. We're going to look at some of the executive orders that are really impacting the labor and employment law and workplace safety space, along with what's happening with some of the regulatory freezes. We're going to, and I'm not going to get into all of the outstanding Supreme Court cases because I was working on this presentation up until the absolute last minute allowed by the ACC yesterday, trying to keep up with it all because things are happening so fast. So I've put just a few key provisions into these slides. And of course, I encourage everyone to bookmark and keep watching all the developments with all of the Supreme Court decisions we expect to be coming out. And then we will talk about some important workplace safety topics. And along the way during our presentation, provide practical tips for employers. All right, so take us now to our Department of Labor staffing. So we have a very interesting situation that this is the first time I've seen it happen in my adult years, and being someone who's always been really involved in political developments and do a little bit of government relations in addition to my private practice. But we have a very interesting situation in that our Secretary of Labor, who's now been confirmed by the Senate, Lori Chavez DeRemer, she is a Republican who has actually been endorsed by the Teamsters. So, given the populist leanings of the current administration, there's a unique thing happening in Washington now where we have, conservative leaning individuals in these posts who are, maybe somewhat supportive of labor interests. What I hope happens with this within the Department of Labor and all of these important functions that the Department of Labor monitors is that, we may be able to see more of an engagement now with frontline workers through use of safety committees, through getting union involvement. And as someone who spends a lot of time on workplace safety type of topics, I really hope that what happens is that we can come away with some updates and modernization of some of our standards so that we can really keep employees safe. So this did create an interesting dynamic with this particular nominee, where she was confirmed with a 67-32 vote and actually had more than a dozen Democrats supporting her nomination. And in recent years, we just haven't really seen that with a lot of one party's nominations. Because of her support of the PRO Act, we did see 3 GOP senators voting against her because of their concern of how she may view labor organizing priorities. And that's Rand Paul, Mitch McConnell, and Ted Budd. And then the next nominee who has just been confirmed is Keith Sonderling. This is a familiar name to many of us, and some of you may recognize him too. Keith is the former EEOC commissioner. And with he's been around the Hill for a while. So his was, as we would expect on some of these nominations, his was a strict party line vote, 53-46 along the party line. I've been able to sit in and listen to him present a few times, and I think he's going to give us also some modernization to some of the roles that the Department of Labor oversees. And one of the ideas that Keith Sonderling has been championing is the use of AI. So look for him to look for ways to embed AI into some of the processes within the Department of Labor. And some of the things that he's interested in is seeing if there's a way that AI can help to remove the human bias from employment decisions through doing things like focusing on job relevant factors and discarding protected characteristics like race, sex, national origin. And as he's explained in some public statements he's made about it, is what he really likes about AI is if you use an AI tool to screen an applicant, if it's just strictly, for example, screening your position descriptions, screening resumes, an AI device is not going to know right away if is someone who's male or female, is not going to know that person's race. And if it's trained properly, it can really look past all of those protected characteristic skills. And as our firm has really embraced AI as well. And a caution I would have, and something that Mr. Sonderling has mentioned as well, is that there are some biases that we still see even with AI. For example, we have tried to get AI to do a mock run and set up a presentation from lawyers. And when you see what AI thinks lawyers should look like, it's just your very stereotypical Caucasian males being set up in the photographs to portray lawyers. So as he notes, it's still it's going to have to be looked at closely as it scales and really have a lot of good trainings that go into it to make sure that it is not improperly looking at protected characteristics. And then our next nominee is Dave Keeling. Have the privilege to know Mr. Keeling quite well. He and I worked together at Amazon when I was there working with their workplace safety legal program and also with their standards and compliance team. So Mr. Keeling has a very interesting background, and I believe he's going to really bring a common sense approach to safety. He has really literally worked from the ground up and he started out as a package handler at UPS in back in 1985. And I learned from him recently, he was actually a member of the Teamsters and he's been endorsed by the Teamsters. And then while at UPS, he starts at a package handler doing all the roles that you can do within that job family, works his way up to being the head of safety at UPS, spends all of his career there until leaving in recent years to going and heading transportation safety at Amazon. So he's going to bring quite a high industry reputation to this role. He's been endorsed by management side uh, types of trade groups, as well as I've mentioned the Teamsters. There are still some detractors who are worried that with both Amazon and UPS having a high level of focus from OSHA on ergonomics issues and heat illness issues in particular, there are some detractors such as Public Citizen who are concerned about that. So it's going to be interesting to see what happens within this administration. So some things that we expect to happen under Mr. Keeling's watch, heading OSHA once he's confirmed, assuming he is confirmed, and we think he will be. I've heard him say that he really intends to modernize the industry. And as we'll talk about when we get to the slides on pullback of old outdated guidance, he is going to really be welcoming opportunities for OSHA to do opinion letters, to weigh in on how to modernize things, and he's going to be a champion on updating things. Some other things that I expect may happen, and I don't know this from Mr. Keeling because he's not allowed to publicly say what he will do, but these are some things I expect that he'll do. I expect there to be some potential rollback of electronic record keeping rules on the OSHA side. As those of you who help your departments look at electronic reporting requirements for your OSHA 300 logs, you'll see that has flip-flopped all over the place in recent years. So I expect that to go back to what we would have seen during the first Trump administration. Expect to see an end of all of the public data dump. Some of you may remember that the Biden administration gave everyone a gift at the end of its administration by dumping about 900,000 details of workplace safety incidents that it collected from employers' logs. So I don't think that will happen. The walk around rule is kind of out of OSHA's hands at the moment. That's the one that will allow a union representative, even if they aren't a company's employee, to come in and walk around while an inspection's happening. I expect to see that that may change some, but that's already made it, that's pretty far through, and that's now being challenged in the Texas federal court system. So everyone should continue to watch that. OSHA's heat rule is uncertain, though based on some things I've heard discussed recently, I don't expect that the heat rule will disappear completely, but I do expect that it's going to be changed significantly. And there are public hearings that will be coming up in June where people will get a chance to weigh in on that. So what we expect to see happen with the heat rule is it's going to be changed to a more performance-based standard more than likely, instead of the one size based all. And from lessons learned during the COVID-19 years, expect that there will be some focus on what to do with infectious disease, though I don't think that we're going to see a massive infectious disease standard coming our way. And as Jennifer will talk about a bit when we get to her slides, it's going to become all the more important for state plans to really watch their own state regulations. And so I think especially on heat, we're going to see more and more use of state plans putting forth heat standards. And then the additional nominees still waiting to get through the process. I have some content here on them. We have all of these are going to have to go through the Senate confirmation process. I'm going to spend most of the time talking about Jonathan Berry and Andrew Rogers and John Snare, because they will have really the largest impact on what I believe on those of you who are watching this presentation. We do also have Wayne Palmer, who is going to be heading up, he's the nominee to head up the Mine Safety and Health Administration. What he's been doing most recently is there's a process to take all of these Department of Labor nominees through and prepare them for their Senate confirmation hearings. Wayne has been heading that up while he's waiting on his process. Dave Aronowitz will be, he's the nominee of the head of Employee Benefits and the Security Administration. He does not have a date yet, and I'm not seeing him be prepped. So I don't expect that he's going to come through within the next 45 days, but you never know how things could move along. But Jonathan Berry and Andrew Rogers they're being prepped now for their confirmation hearings. So I believe they will be fast tracked, and I do expect you'll see them having their hearings set up very soon. And so some background on them. So Jonathan Berry, as in his role as the solicitor, this would make him the chief legal officer at the DOL, and this will provide him with independent authority to initiate lawsuits falling under any of 180 federal labor laws that fall within the Department of Labor, including topics under the Fair Labor Standards Act and even some things that could fall under the OSH Act. Barry is currently in private practice where he's the managing partner at Boyd and Gray and Associates. And prior to this, he served as the acting Assistant Secretary of Policy for the Department of Labor during the first Trump administration. And then in that, he worked on a lot of rulemaking. He previously has held roles with the Department of Justice's Office of Legal Policy, where he assisted with judicial nominations and regulatory guidance. And then during he's also been during the transitions of the Trump administration, he has served as chief counsel to the transition team, advising on matters of ethics and policy. And then one area where he's getting a lot of press is that he authored Chapter 18 of Project 25's or Project 2025's mandate for leadership. And this is where he is advocating and outlining policy recommendations for the Department of Labor, including rollbacks on diversity, equity, and inclusion initiatives, modifying overtime rules, redefining the independent contractor status, protecting small businesses, relaxing certain hazard regulations, and prioritizing American workers through immigration reforms. The next one I'll talk about is Andrew Rogers. Andrew has spent some time within the various roles within the Department of Labor and has some experience in this area. And so as head of the Department of Labor's Wage and Hour Division, he'll have broad enforcement responsibilities for federal labor standards that will impact, all of our workers, our 7.3 million or 7.3 employers nationwide. And this will give him the opportunity to oversee enforcement of some of our core labor provisions. And I won't go through all of them because there are so many, but the ones I think all of us on this call will look at the most closely will be the Fair Labor Standards Act and their provisions on minimum wage, overtime pay, record keeping, and child labor, the and Medical Leave Act, Migrant and Seasonal Agriculture Worker Protection Act, Employee Polygraph Protection Act, and field sanitation and housing standards, and of course, many other things such as prevailing wage enforcement under the Davis-Bacon Act and Service Contract Act. And watch for things, those of you who monitor Davis-Bacon Act, just really continue to monitor it. I would even set a news alert with those terms keyed in because I expect things are going to be happening very quickly as it pertains to the requirement to have that on federal contracts, along with all of these D&I things that we'll be talking out throughout the day. Mr. Rogers is current acting general counsel at the EEOC, and prior to that, he served as chief counsel to the EEOC acting chair, Andrea Lucas, and was the senior advisor at the WHD during the first Trump administration. Henry Mack is nominated to be the head of the Employment and Training Administration. No date on him yet and no indications that he's being fast-tracked, so that one may take just a bit longer. And then the next one I'll talk about is John Snare, and very interesting things happening at the OSHA Review Commission. So a lot of people may not realize this, and I didn't realize this until I was looking at some blogs of a friend of mine who's the previous head of the OSHA Review Commission. But basically, right now, we really have no one on the OSHA Review Commission. The last commissioner whose term is expiring is stepping down. And so John Snare had originally been teed up for one of the roles within the solicitor's office. And so now he's been moved over as a nominee to the OSHA Review Commission. I haven't heard yet if there's a date set for his nomination, and I haven't seen it. And I haven't seen any indication that he's being prepped for a hearing yet. But my prediction is he'll be the next one teed up just because they have to get someone in. There's no quorum currently at the Review Commission. I also hope that we will start to see more nominees coming to the OSHA Review Commission and soon because we need it. And then the ones that are on this slide, none of these require Senate confirmation. So all of the ones here are appointees who are able to quickly get their feet on the floor and start working. So all of these folks are able to go ahead and start leveraging what they're able to do within these roles, such as the chief of staff, deputy chief of staff. And one that I've been working with pretty extensively lately is Amanda Wood Laho, who's now the Deputy Assistant Secretary of OSHA. And so until Dave Keeling is confirmed as the head of OSHA, Amanda is serving as, for all intents and purposes, the acting head. And she has a long career within various roles within OSHA, within the Department of Labor, including having served on the, having assisted the Review Commission in other capacities. And now I will turn to the National Labor Relations Board updates. I'm going to try to get through this as quickly as I can, but there is so much here that I could literally spend the full hour. And I know that a lot of you on the call are going to be very interested in the labor side of things. So if there's anything that I've had to skip over quickly, just so that we can get to all of our other material. If you want to reach out to me afterward, I'm definitely happy to chat with you and give you any other input. So things are happening on this so fast. It is making all of our heads spin. I waited until I'm sure the organizers here were getting a little worried when I was going to give them our slides yesterday because I waited until just the last minute to finally let the ink dry on our PowerPoint to see if anything had happened here because there has just been so much. So this is as up to date as I could get it as of 3 o'clock yesterday. Um, for all I know, I've woken up this morning to there being news I've missed, but here are all the things that have happened. So, with our NLRB board members, I think most of you probably know that they do serve 5-year terms, and they're staggered in such a way that the intent with these board roles is you want to try to have a pretty even mix between, Democratic appointments, Republican appointments, and then with just all the gyrations that's happening right now, that is just really getting to be in jeopardy. So our former chair, Lauren McFerrin, was not confirmed in December. Her term expired at the end of the Biden administration in 2024. So President Trump then named Marvin Kaplan as the chair on January 20th, 2025. We still have David Prouty, a Democrat, remaining on the board, and his term is one of the staggered ones that will not expire until 2026. And then and I have here unprecedented move because this truly is unprecedented and has been subject to just so much litigation. So he actually fired board member Gwen Wilcox, and there's been a lot going on with that. Um, we have even had to have the Supreme Court weigh in. So she was originally reinstated on March 6th of 2025. The Supreme Court then weighed in and issued a temporary stay on April 9th of 2025, blocking her reinstatement while it considers the legality of her removal. So that is as current of a status as I can get it while that's being weighed. And it is really just so important to get all of this ironed out because the NLRB must have 3 members to have a quorum. And without a quorum, the board is not able to issue any decisions. It cannot engage in any rulemaking. And in the absence of a quorum, the board's regulations would provide that the NLRB's chief administrative law judge then would have to step in and rule on any requests for special permissions to appeal, motions for default judgment, summary judgment, dismissals of unfair labor practice complaints, even though those complaints, those decisions cannot even be appealed to the board or ruled on until a later date. And so with all the staffing cuts, people resigning, all of that, as you can imagine, that has to be putting just a tremendous strain on the chief administrative law judge. And then some other impacts that this has is that, until the Supreme Court decides whether she can return to her seat, this just sort of blocks the ability potentially to maybe appoint another member so that we'll have enough there. And so Wilcox has used the district court system of the District of Columbia for that uh, lower court case. And as I mentioned, it's just so unusual now to see us having to use the Supreme Court so frequently to get ahead of just making sure that we have quorums on these boards. The next update I have is on the general counsel. This too has had things happening so fast, I feel like I'm watching a tennis match. So these slides I've brought as current as they could have been as of yesterday afternoon. So Jennifer Abruzzo, who was appointed during the Biden administration, was terminated as general counsel in January 2025, quickly after President Trump took office. And so we've had a revolving door with people coming in and coming out. Jessica Rutter briefly served as acting counsel, but she too was terminated by President Trump. And then William B. Cowan has now stepped in to be the acting general counsel as of February. And then Crystal Carey has recently been nominated to serve as the next general counsel pending Senate confirmation. And so these continual leadership changes and ongoing legal disputes are really hampering the board's ability to direct and really issue decisions in the near future. And with I do want to say though, so I mentioned that on the previous slide how unprecedented it was to come in and fire a board member. It is not so unusual to come in and remove the general counsel. So that's to be expected because President Biden, on his first term in office, he did fire John Ring, who had been nominated in that role during the prior Trump administration. So that kind of thing is not so unusual. So we just hope that these general counsel roles get settled quickly so that at least there is some leadership within the NLRB. Because what is so important with the NLRB is, as those of you who do any sort of labor relations work, you'll know that during the previous term of the NLRB, there were a lot of aggressive actions from the standpoint of an employer, and some of those remain very uncertain, especially as it relates to some of these executive orders and general counsel memos that seem to be changing this. So some of the things that have happened on that front is that almost immediately upon his appointment, acting general counsel Cohen began to go in and pull back various things from the previous administration, including arguments that were addressing the constitutionality of the NLRB structure and expansion of remedies that some thought were in violation of the Seventh Amendment right to jury trial. And that's related to the SpaceX case. And SpaceX is seeking a review of that decision and whether application of extended remedies is going to be allowed. And some of these extended remedies would include things that would really limit an employer's rights to communicate with employees prior to votes on certain issues. It's going to really impact the status of these is going to really impact organizing and what employers can do, what they can communicate, how they can communicate. And so expect a lot to be happening on that front. Another thing that has happened under the NLRB is that with Cowen's direction and the firing of some of these individuals that implicate a lack of a quorum, I think we're going to see a more cautious stance on constitutional challenges and a shift away from the previous expansive policies. And that's coming from, I believe you'll be receiving these slides. So I encourage you to click on that hyperlink to General Counsel memorandum from General Counsel Cowen and see what that notes there about reversing some of those prior positions. Other things coming with the withdrawal of these memos, CMEX, the CMEX and McLaren Macomb matters affecting those memorandums. Those now withdrawn GC memorandums have provided directives on how to interpret and comply with those. So expect the board is going to move away from the CMEX decision. And the general counsel is also expected to ask the board to overturn McLaren Macomb. And so what's important here in looking at these is that with CMEX, when the impact of CMAX is that when a union requests recognition based on claimed majority support within an appropriate bargaining unit, an employer must either recognize and bargain with that union or file an RM petition seeking a representation election within 2 weeks to then hold a secret ballot election to confirm the union's claim of majority support. So failing to file that or recognize or bargain with that union could actually trigger a ULP, as changes to employee terms and conditions after the union demands recommendation could trigger some issues. So what CMEX did is represented a major expansion of the board's historical use of bargaining orders as a remedy for ULPs. And then I'm going to just skip past McLaren Combe because we're getting close to the end of our time. But essentially, while both of those cases do still remain good law at the moment and remain good law as of today, it's very much likely that the acting general counsel or a newly appointed and Senate confirmed general counsel will find a way to challenge these cases and raise those issues before a newly comprised National Labor Relations Board, when we have one, who could potentially reverse or overrule them. So in the meantime, any memos that don't provide guidance on those cases and have been decided by the NLRB, we anticipate that General Counsel will issue new directives shortly that will address any of these memos that he's rescinded. So I have a slide on some additional memorandums. There are 31 of them in all. And in fairness to Jennifer, I want to get the turned over to her quickly. So obviously not going to go through all 31 of these. You have another presentation today covering executive orders, but packaged within these are some of the ones employers have been watching the most closely, such as what is going to happen with non-competes, the stay or pay provisions, student athletes as employees. And I was surprised to see Nick Saban on the news with President Trump talking about what could happen with, like the student athlete portal. So expect to see with with some of these memos and what's happening with those memos is expect to see a shift toward a more employee-friendly enforcement priority from this administration of the National Labor Relations Board. And so what employers should really do next in terms of looking at, how to stay on top of these, until you're told differently, everything you thought you knew about the National Labor Relations Act does still remain in effect. But just really keep your eyes glued on news alerts and on what's happening. My firm, if you want to bookmark us and look for our insights, we also issue rapid fire insights to keep everyone up on what's changing. But here are the big things that you really need to be watching currently is what is the impact going to be on representative petitions and union elections, regional director decisions and representation cases, and the status, how are ULPs going to be handled going forward? And what's the board's regional office handling that matter going to do? So until you're informed differently, we're all going to assume that these will continue to be investigated and processed as usual, and you'll still get your hearings, you'll still get your decisions from an administrative law judge. Certain labor injunctions, those may be in flux. But now continue to follow what you always have done when you face an issue, when a union boycotts or strikes in an attempt to force an employer to the table and to ultimately recognize them. The board does still have the right to file a Section 10L petition to try and block that action from continuing. And then until a quorum is present on the board, these are all of the things that are stalled. So the previous things I went through can still go through at business as usual. But for all of these that I have listed here, we do need the quorum in place to have this happen. So that, appeals, that's pretty important, right? Certain types of injunctions, issuance of regulations, that's kind of at a standstill because how are you going to do any sort of new rules, rulemakings, those kinds of things? Reviewing contested representation elections, which is going to be the most of them, I would think. Enforcing subpoenas, and then even simple things like requesting reviews. Because parties can go straight to the board to submit requests for review in certain cases. And now without a quorum, that can't even be happening. So what comes next for the NLRB as we get these new folks and new issues in place? I have all of this listed here with narrower interpretations of who qualifies as an employer under the NLRB. What is going to be protected concerted activity, that is very likely going to be more limited. The board is going to move away from broader remedies, as we've talked about on previous slides for ULPs. Um, the previous guidance that aggressively challenged non-competes, that is going to be rescinded, giving employees a little bit more leeway on those. Greater flexibility to implement workplace policies and rules. And, going back to a lot of us have really been afraid to put confidentiality and civility rules into our handbooks. So that's likely going away, and that, you may be able to do that again. And most definitely, I think we're going to see rollback of an extended definition of joint employer. And so I will stop with this and let Jennifer take it away for our EEOC updates.
Yeah, thank you, Robin, and thank you to the ACC for having me. Next slide, please. Okay, so a lot, as Robin has mentioned, has gone on in the first 100 days of Trump's second presidential experience. So as we know, Trump has appointed Republican Andrea Lucas as the acting chair of the EEOC. He removed Carla Gilbride, who was appointed during the Biden era for her role as a general counsel. Now, this was not surprising. It was expected, but removing the commissioners, Jocelyn Samuels and Charlotte Burrows, two of the three Democratic commissioners, was very surprising and far from routine. In fact, Samuels has filed suit last month challenging her removal. So you need to look at this in parallel with firings at the NLRB as an indicator of the potential elimination of other forms of affirmative action. Prior to Samuels and Burrows' removal, the EOC had a Democratic majority, which would have limited acting chair Lucas's authority to press her and President Trump's priorities until at least mid-2026. And what we're seeing is disruption in that. Next slide, please. Okay, and then moving on to EOC personnel shifts. Oh, no, sorry, enforcement priorities. According to Chair Lucas, I think we're one forward, Robin.
I apologize. Give me 1 second, having some
No worries.
difficulties with these.
I'm kind of clipping through these because I know time is of the essence.
Sorry about that. It's a bit challenging to try to advance on this panel. So is this the slide now?
Yep, perfect. Okay, so Lucas has outlined several key priorities for her tenure. You can see those over here. In addition, she's explained that there's a priority to defend the biological and binary reality of sex and related rights, including women's rights to single sex spaces at work. And as we know, this is consistent with President Trump's executive order that's entitled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. This executive order states that's the policy of the U.S. to recognize two sexes, only male and female. And also instructs federal agencies to adopt and apply these definitions and to remove all statements, policies, regulation forms, and communications that promote or otherwise inculcate gender ideology. So we're going to see a lot more movement along these lines. In addition, Lucas is focused on protecting workers from religious bias and harassment, including anti-Semitism, and then with some ambiguity, remedying other areas of recent under enforcement. Next slide, please. So new joint EEOC and DOJ guidance on DEI, which was released in mid-March 2025, identifies DEI practices that may be unlawful if the employment action is motivated, even in part, by the employee's protected categories. We have, we've seen an uptick in lawsuits that are filed by men and women who are Caucasian, which it aligns with President Trump's and the EOC's uh, agenda. So the latest on the joint EEOC and DOJ guidance on the DEI uh, front was issued on March 19, 2025. There's two technical assistance documents that clarify how Title VII and the Civil Rights Act apply to DEI initiatives in the workplace. They all of these emphasize that the DEI programs may be unlawful, and it clarifies that it prohibits disparate treatment in hiring, promotion, compensation, exclusion from training and fellowships, firing, demotion, fringe benefits, and exclusion from mentoring or sponsorship programs. So this new guidance significantly restricts how employers may implement DEI programs under the federal anti-discrimination laws. Now note that this does not necessarily affect state anti-discrimination laws. Next slide, please. So what can we expect next from the EEOC? Well, as we know, Jocelyn Samuels has filed suit challenging her termination, and she and Burroughs will undoubtedly rely on a 1935 opinion entitled "From Humphrey's Executor versus the FTC," in which the United States Supreme Court analyzed then President Hoover's removal of commissioners from the FTC. The Supreme Court held in that ruling that the FTC Act only allowed the president to remove an FTC commissioner prior to the end of the term based on specific grounds. And those grounds do not apply here. So it'll be interesting to see how the United States Supreme Court comes down on any appeal that's filed with it. Now, there is one Democrat remaining, Coda Gull, whose term expires in July 2027, but that still leaves 3 open seats that the Trump administration will need to fill. He'll likely seek to fill the empty seats with candidates who will press his enforcement priorities. And, we'll just have to wait and see how Samuel and Burroughs, primarily Samuel's lawsuit, pans out. So as of now, there's been no changes to EOC's guidance on existing matters prior to the 19th of March. So we'll just continue and keep our eye on what's coming down the pike. Next slide, please. Okay, independent contractor rule. Now, followers of this rule and employee classification legal developments will recall that during the first Trump administration, it issued an independent contractor rule in the final days, and it significantly clarified the standards for determining independent contractor status and generally expanded the instances in which a worker could be deemed an independent contractor. Soon after President Biden took office, there was an attempt to delay implementation of that rule and then a rollback. Biden administration then created its own rule, and which ultimately led to the rule at issue here being finalized in January of 2024. Now, the independent contractor rule, we expect that it will significantly roll back and change the Biden era rule, which I think there's been a lot of recent promulgation and news about it. Next slide, please. Let's talk about restoring equality of opportunity meritocracy. So just as of almost last week, the Trump administration presented an executive order called Restoring Equality of Opportunity Meritocracy, and you can click on that link to find it. The stated purpose is to eliminate the use of disparate impact liability in all contexts, to avoid violating the Constitution and federal civil rights laws. Now, what does this mean for you as an employer? Well, it'll initially impact federal agencies, including actions that may have been taken against employers. So employers that are facing these actions by the agencies are premised upon a disparate impact theory. And they may be able to use this executive order to limit or stop the agency from continuing their enforcement actions against them. And we've already seen some of that action out in the marketplace. The impact of this executive order on private litigants is currently uncertain. And without action by Congress or the Supreme Court, it's unlikely that the disparate impact liability will become obsolete. Okay, next slide. Quickly touching on the Federal Labor Relations Authority and the Merit Systems Protection Board. The FLRA chair, Susan Grunman, was terminated, but then ordered reinstated by the court on March 15th. And then the MSBP or PB chair, Kathy Harris, was terminated by Trump, and a federal court judge reinstated her temporarily. Then on March 28th, a three-judge panel of the DC Circuit stayed that reinstatement. And then, like the tennis game Robin alluded to earlier, on April 7th, the DC Circuit Court vacated the panel stay and reinstated Harris. Next slide. Okay. Well, the Supreme Court is poised to consider whether to uphold or overturn Humphrey's executor, which I alluded to earlier, regarding the reinstatement of Burroughs and her colleague. Again, this is a foundational case that limits the presidential removal power over independent agency officials. But it'll be interesting to see what happens with that. So the Supreme Court, again, in that case, held that the president cannot remove commissioners of independent regulatory agencies like the Federal Trade Commission. And so that decision distinguished between purely executive officers who can be removed at the will of the president and officers of independent agencies. So just a little bit more background. And again, it'll be interesting to see what occurs in that arena. Next slide. And sorry, I'm going fast because we have a limited time. So labor and wage law. So a recent case that came down on January 15th, 2025, the Supreme Court unanimously ruled that employers must prove Fair Labor Standard Act exemptions, such as for outside sales employees, by a preponderance of the evidence. Now, this rejected a higher, clear and convincing evidence standard used by some circuits. So this is a change. It's a lower standard. And this decision now standardizes the evidentiary burden across jurisdictions and benefits employers in their defense against misclassification claims and overtime pay lawsuits. Okay, next slide. And then I'll turn it over to Robin. Okay. In a pivotal workplace safety ruling, Loper Bright Enterprises, which came down on June 2024, the court struck down the longstanding Chevron deference, which we all know its widespread impact right now, limiting federal agencies' authority to interpret ambiguous statutes. It clarified that courts, not agencies such as OSHA, have the final say on statutory interpretation. And this will likely restrict OSHA's regulatory reach. How it's going to affect it, we haven't quite seen that fully pan out yet. So Robin, I'm going to turn it over to you.
Thank you, Jennifer. All right, now we'll get into the regulatory freezes and executive orders. So, and this happens with any administration. So this is not new for the Trump administration, but when a new administration takes office, the first thing they do is immediately direct all executive agencies to halt the issuance of any new rules until they have a chance to have those reviewed or have a new agency head who's been appointed by the president look at them. So what's happening now is that any rules that have not yet been published have been immediately withdrawn so they can be reviewed and approved, or potentially even consider a 60-day postponement period. And that 60-day period would also include opening comment on rules that have been published but are not yet in effect, such as the OSHA heat rule that some of you may have been following that would apply to indoor and outdoor heat illness cases. So the impact of this is, and the impact of the issuance is about regulatory freezes and everything going on with regulations, is that President Trump issued another executive order. And this one requires that for every 10 regulation, or for every new regulation that comes in, 10 have to be eliminated. And something that I had clarified recently that I was very pleased to hear, this does not mean laws. This does not mean 10 regulations. This could be an interpretive letter. This could be an opinion memo. And I was able to hear Keith Sonderling speak about 2 weeks ago talking about this. And so something for all of you to know and also to take back to your trade organizations that you work with is that this administration is in all of these departments that take opinion letters and issue interpretive guidance. They are looking for opportunities to modernize these agencies. So if you see rules that are outdated, like for example, I know within the OSHA interpretations, there are 2 letters of interpretation that say the exact opposite things about how you store lithium batteries. So that's an example of where the administration could use an opportunity to kick out old, outdated letters of interpretation that no longer apply to technology or doing things today to count within that 10 threshold. So, excuse me, also, if you have new ones, you can request new ones during this time period. And this is a significant change from the Trump 1 administration, where they just had a 2-for-1 rule. And now they have because he wants to, I guess, build everything better. We now have a 10-for-1 rule instead of a 2-for-1 rule. So that is, I've jumped out of that as quick as I could to get Jennifer over to the important OSHA update.
Thank you, Robin. Next slide, please. Okay, a couple key things have happened in the last few months. First, the occupational exposure to COVID-19 healthcare settings was withdrawn in January 2025. The justification given was to focus on infectious disease standard for healthcare workers. But this does not supplant the need to have exposure control plans in certain industries. So keep that in mind if you are an industry that is mandated by the regulations to have an exposure control plan. You want to make sure that you're reviewing that and updating it every single year per the regulation. The pending infectious disease standard, OIRA, concluded its review on January 14th, but it also shows that the standard has been withdrawn. Just want to note that some state plans do have an infectious disease control standard. So if you are in one of the 20-something state plan OSHA jurisdictions, double check and either confirm that, in fact, the infectious disease standard has been promulgated and comply with it in your state, or determine that it's not applicable. Next slide. Okay, OSHA proposed an emergency response standard. It was published on the 4th of February 2024, and comment period has closed. Public hearings were held, and post-hearing comments were due back in January of 2025. It's unclear whether this will be reopened for further comment. And over 42,000 or 4,200 comments were received. But this seems to have kind of come to somewhat of a standstill or impasse. We'll see where it's going in the near future. Next slide. Okay, here is a slide that Robin put together that offers some background and links to rulemaking. It's a great resource, one that kind of a cheat sheet of where you can find some additional information. Next slide. Okay, top concerns and unanswered questions regarding the OSHA heat standard. So the heat measures to address heat will be required when temperatures reach 80 degrees. I will tell you that based on our operations in the construction industry across the United States, it can be varying if a state plan applies. Like, for example, in Florida, it's a higher temperature. But it's something that you need to keep track of where that standard or where that heat index needs to be in order for uh, additional measures to be put into place to protect workers. Employee consultation is mandated in this rule, meaning that you have to talk to the employees and involve them in creating your plan. This is in conjunction with the walk-around rule and is an area that's ripe for involvement with labor interests, especially if you obviously have a unionized workforce. The requirement of the rule has heat safety coordinators. This is likely to place a significant burden on employers, especially smaller companies, in appointing them and possibly expanding their duties, especially if the heat safety coordinators are unionized employees. You may have to discuss it with the business representative. Now, the rule does not provide context on whether the heat safety coordinators can be doing other jobs or other guidelines. Next slide, please. So there was a national emphasis program that was focused on heat injury illness prevention issued in 2022. That was recently renewed and I believe it expires now in April 2026. So be cognizant that even if you're in a state that follows the federal regulation, there's a national emphasis program. And I can tell you based on my experience, when OSHA has either conducted programmed inspections or inspections related to employee complaints, they will double check and ask and spend quite a bit of time asking what your heat injury illness program looks like. They'll also interview employees and make sure that you're just not giving lip service to it. They will ask the employees what measures are put in place, and they'll ask to see evidence that it has been talked about repeatedly, that there is indications that the guidelines are being followed. Next slide. So what's next? The 120-day comment period on the heat illness injury prevention plan was extended to January 14th of this year. There were over 24,000 comments. You can view the comments by clicking on the link. There's an informal public hearing on June 16th, and there'll be post-hearing written comments and post-hearing legal briefs. Next slide, please. Robin was so kind to also put together this great chart of the state OSHA plans and their requirements around heat injury illness prevention. So this is a great cheat sheet on what you can do as an employer to comply with state heat plans. There are pending state regulations in certain states. New Jersey, Colorado just issued one. Pre-existing state plans that have these programs include Oregon, Washington, and California. I can tell you my business operates in Minnesota, and Minnesota has also been very active in enforcing its heat injury and illness prevention plan. Robin, I'm going to pitch it over to you for closing.
Thank you, Jennifer. I really appreciate that. And yeah, as Jennifer noted, a lot going on with that heat rule. So just keep watching it and keep watching your state plans.